Hello, this educational video is brought to you by the Colorado HOA Information and Resource Center. The topic of this video presentation pertains to the records of the association. The information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. Association records. An association has obligations to its owners concerning the maintenance and production of records. These obligations are set forth in Section 38, 33.3, 317 of the Colorado Revised Statutes, which is the Colorado Common Interest Ownership Act, also known as Kiowa. The association record obligations consist of maintaining records, the types of records to keep, the disclosure of documents to owners, records to be withheld, and the timing and costs for providing records. In addition to any records specifically defined in the HOA's declaration or bylaws or expressly required by the Kiowa law, the HOA must maintain a number of records, all of which are the sole records of the HOA for purposes of document retention and production to owners. Some of these required documents include detailed records of receipts and expenditures affecting the operation and administration of the association, records of claims for construction defects and amounts received pursuant to settlement of those claims. Also, the association must maintain minutes of all meetings of its unit owners and executive board, a record of all actions taken by the unit owners or executive board without a meeting, and a record of all actions taken by any committee of the executive board. Additional records to maintain are those written communications and the votes cast by executive board members that are directly related to an action taken by the board without a meeting, or directly related to an action taken by the board without a meeting pursuant to the association's bylaws. Additional records include the names of unit owners in a form that permits preparation of a list of the names of all unit owners and the physical mailing addresses at which the association communicates with them, showing the number of votes each unit owner is entitled to vote. Also included in the association's records are its current declaration, covenants, bylaws, articles of incorporation, if it is a corporation, or the corresponding organizational documents if it is another form of entity, its rules and regulations, responsible governance policies adopted pursuant to the Kiowa law, and other policies adopted by the executive board. The association's records also include financial statements for the past 3 years and tax returns of the association for the past 7 years, to the extent available. In addition, the association must maintain a list of the names, electronic mail addresses, and physical mailing addresses of its current executive board members and officers. The association should also have available its most recent annual report delivered to the Secretary of State's office, if any, and financial records sufficiently detailed to enable the association to comply with the Kiowa law concerning statements of unpaid assessments. In addition, the association must have on hand its most recent reserve study, if any, as well as current written contracts to which the association is a party, and contracts for work performed for the association within the immediately preceding 2 years. Additional records to maintain are those of the executive board or committee actions to approve or deny any requests for design or architectural approval from unit owners. Also, any ballots, proxies, and other records related to voting by unit owners for 1 year after the election, action, or vote to which they relate. Finally, the association must maintain all resolutions adopted by its board of directors related to the characteristics, qualifications, rights, limitations, and obligations of members or any class or category of members, as well as all written communications within the past 3 years to all unit owners generally as unit owners. Examination and copying of records by a homeowner. All records maintained by the association must be available for examination and copying by a unit owner or the owner's authorized agent. Notwithstanding any provision in the declaration, bylaws, articles, or rules and regs of the association to the contrary, the association may not condition the production of records upon a statement of proper purpose. The association may require unit owners to submit a written request describing with reasonable particularity the records sought, at least 10 days prior to inspection or production of the documents, and it may limit examination and copying times to normal business hours or the next regularly scheduled executive board meeting if the meeting occurs within 30 days after the request. With regard to an association membership list, a membership list or any part thereof may not be obtained or used by a person for any purpose unrelated to a unit owner's interest as a unit owner without the consent of the executive board. Without the consent of the executive board, a membership list or any part thereof may not be used to solicit money or property unless such money or property will be solely used to solicit the votes of the unit owners in an election to be held by the association. Also, cannot be used for any commercial purpose, or the list cannot be sold to or purchased by any person. There are certain records that can be withheld from a homeowner. Certain records maintained by an association may be withheld from inspection and copying. Records that can be withheld include architectural drawings, plans, and designs, unless released upon the written consent of the legal owner of the drawings, plans, or designs. Contracts, leases, bids, or records related to transactions to purchase or provide goods and services that are currently in or under negotiation, and communications with legal counsel that are otherwise protected by the attorney-client privilege or the attorney work product doctrine. Additional documents that can be withheld include disclosure of information in violation of law, records of an executive session of the executive board, individual units other than those of the requesting owner, and the names and physical mailing addresses of unit owners if the unit is a timeshare. There are also association records that must be withheld from homeowners. Certain records maintained by an association are not subject to inspection and copying, and they must be withheld if they pertain to certain matters. This information includes personnel, salary, or medical records of specific individuals, personal identifying information of residents, including bank account numbers, phone numbers, email address, driver license, and social security numbers. However, a resident can provide the association with written consent if it wants to publish to other members and residents its phone number and email. The association can impose a reasonable charge and collect that in advance to cover the costs of labor and materials for copies of the records. The charge may not exceed the estimated cost of production and reproduction of those records. There is a right to receive copies by photocopying or by electronic transmission if available. There is no obligation for the association to compile or synthesize the information, and the information in those records cannot be used for commercial purposes. Additional information regarding association records can be found in the Colorado Revised Nonprofit Corporation Act, Section 7-136-101 to Section 106, and it covers corporate records, the inspection rights of the member, court-ordered inspection, limitations on the use of membership lists, and financial statements. This has been an educational presentation from the HOA Information and Resource Center. Following this presentation, you will find a short quiz and some HOA resources. Thank you for watching.